SJC-13351, Commonwealth v. Oscar Delossantos.
Okay, Attorney Spurlock, whenever you're ready, take your time.
Thank you. May it please the court, Matt Spurlock for Oscar Delossantos. The central issue in this case is straightforward. Competent testimony requires comprehension, and the testimony of uncomprehending witnesses cannot satisfy the Commonwealth's burden to establish a valid warning was given before questioning began.
I think it's a little more complicated than that. So, and the motion to suppress, the way it's raised as if there's no warnings given in Spanish. It's not raised as if the warnings weren't complete or accurate.
I agree with that, Your Honor. And that is our position, that no warnings were given in Spanish, and that's been our position consistently.
Right, but that's a little hard to believe. When we know that the very purpose for which the Spanish-speaking officer is brought there is to give that. And although the officers can't testify, whether he properly instructed under Miranda, they probably can tell whether he's speaking Spanish or not.
They might be able to tell whether he's
And they certainly know that they called him there to give the warnings in Spanish, and he came, and he's a Spanish speaker, and he's speaking in a foreign language. I mean,
I agree with all of that, but Justice Kaffer, you're describing an assumption, and that is an assumption that...
I'm describing a reasonable inference that when police officers call a Spanish-speaking officer to give Miranda warnings because they can't give it to someone they're not sure speaks English well enough, is it a reasonable inference to believe that he actually did what he was asked to do? Again, had you brought a claim that says, he didn't give the Miranda warnings properly in Spanish. We have other cases like that. I totally am with you. These guys are certainly incapable of doing that. But this is a different case, and had you actually brought that argument, they could have brought the Spanish-speaking officer to the hearing to testify. But you don't do that, probably brilliantly, because you're at least here. And otherwise, you probably would have lost down below.
I have a couple of responses. The claim that the warning was not given accurately and completely is brought in the new trial motion, and that was a deficiency in trial counsel's part to not press that it was accurate and complete.
Had he raised that issue, now, believe me, I have some issues, and I'll stop interrupting you. I'm not giving you a fair shot here, but I want you to confront sort of the harder part of this case, which is you brought a claim that they didn't give the warnings in Spanish, not that they didn't give them accurately.
Absolutely. I disagree that that's a hard part of this case. I think that resting the finding beyond the reasonable doubt that the warning was given in a language that the witnesses, by their own admission, do not comprehend and cannot understand, can never meet the Commonwealth's burden to establish beyond a reasonable doubt that that warning was given. Just like they can't testify about words that they heard.
I guess, counsel, I still have the same concern as Justice Kafker. The reason why I think this is important is when you file your motion to suppress and you get this bare bones affidavit, the Commonwealth is to look at that affidavit and determine what witnesses they need to call. And if the motion is pressed on the premise that no Miranda warnings were given, the Commonwealth could reasonably do as they did here and call the two officers who were on the scene to testify to, we called Officer Guillermo to the scene to give these warnings. That's a very different case than saying the affidavit saying whatever warnings were given to the defendant were inadequate to voluntarily waive these rights.
So the inadequacy of the warnings, the accuracy and completeness, that's a subsidiary issue that's necessarily contained within the larger issue of whether they were given at all.
I don't know that I agree with you on that.
This is sandbagging. I mean, you can't give the Commonwealth notice. The Commonwealth doesn't call the Spanish interpreter because the substance of the Spanish rights aren't at issue, and then later on you say, oh, you didn't prove it. I mean, Rule 13, as Justice Georges points out, is meant to inform the government who the witnesses are so they can bring the witnesses to the witness stand.
There was no question here that the warning had to be in Spanish, and this was from testimony from the Commonwealth's own witnesses that the warning had to be in Spanish. No one was hiding the ball here. Everyone at the motion for new trial was on the same, at the motion.
Where in the
to
motion
suppress.
does it say that the warnings were inadequate in Spanish, that they weren't, the warnings weren't given properly in Spanish?
That would be helpful. Is the affidavit in support of the motion to suppress, can you just tell us what the record citation is for that?
Yes, Your Honor, let me grab it here. Record Appendix 24 and 26.
24 and 26, thank you.
And it does not say in Spanish in there, but I would rely on Mubdi for the proposition that the purposes of Rule 13 is to put the Commonwealth on notice. These were the Commonwealth's own witnesses, and the first thing, right out of the gate, they said, we knew that this guy needed a warning in Spanish because he didn't understand English. And so that's why we called the Spanish-speaking officer. Now, it's not too much to ask the Commonwealth to talk to their witnesses and figure it out. That was also in the police reports, which are cited at transcript 1.
I agree with you that Mubdi could be a lot clearer what you're supposed to do, and we probably should clarify it. But isn't this proof of the problem? Because they really don't know what you're going to be arguing. And they are, in Justice Gaziano's words, sandbagged by that because they just think it's an issue of whether you actually brought someone there to give the warnings in Spanish.
I don't think it's sandbagging. The fundamental thing that needs to be established here, in addition, it needs to be established that they're accurate and complete, and there's all sorts of problems with that, with translation that we all know about from Vasquez going back.
Totally
The
agree.
really easy case if it's raised properly, because of course someone needs to have the rights understood beyond a reasonable doubt in a language that they speak. We're more concerned about the procedural part of this case, not the substantive part. You win on the substantive part if you get there.
I guess I don't understand.
The waiver issue is bothersome.
I see the waivers. Okay, so the question on waiver then is whether everybody at the hearing was aware of what needed to happen.
Well, could there not have been a request at the hearing for an additional witness or an interpreter, or couldn't it have been raised orally by defense counsel? Defense
counsel certainly could. It may have been better practice to stand up and object to the lack of foundation there of the warning. But in these circumstances, that is not waiver. It was still clear error to rely on testimony from a witness who could not possibly understand by their own admission what was being said.
That would require an objection, right?
Maybe. I mean, objection would have helped, but it doesn't save that testimony from the clear error standard. It was clear error to rely on, it could have been in Aramaic, Arabic, Tagalog, doesn't matter. There was no comprehension of what was said.
Right, we understand what you're saying with regard to the language, and all we're saying is that if you can reach the issue, you would win. But we're still stumbling over getting to the issue because it wasn't properly raised below.
So
that's our view, at least my view at the moment, is that it doesn't look like it was raised properly, and there was an opportunity, even at the hearing, to go a little further and object and do something even then.
So there, if waiver is an issue, if trial counsel wasn't effective, and the ineffectiveness there would be not standing up and objecting, then of course I have my new trial motion. And the new trial motion was based in part on that failure to object.
Yeah, but if he did, then you lose, because then we know what Guillermo would testify to, because we saw what he testifies at trial. Well, if he stands up and objects, say, these guys don't speak Spanish, the prosecutor goes, well, Judge, if we're going to go there, we need a continuance. We'll bring in Officer Guillermo, and then you're going to lose, right?
I don't agree, Justice Kafka, and I don't think it's a foregone conclusion because, as you noted earlier, it's not just that it was given at all. That's one issue. And then the second issue is whether it was accurate and complete. We don't have the card that was used. There's many cases from Vasquez going back that talk about the difficulty.
And I know we're not supposed to take the testimony from trial as say it would have been given at the motion to suppress, but that's sort of the best equivalent right now. And we know that Officer Guillermo is fluent in Spanish, and he testifies to all of this at trial, right?
We do not have the card that he read from, and we do not have his actual translations. It was, according to him, an English language card.
But think about the big picture. There's nothing in any way in the affidavit that says that the Spanish presentation of Miranda was defective. The motion to suppress is about to start. Judge is going to take out the affidavit, look at it, read it, see if there's any issues. Defense attorney doesn't need a continuance. They can just request a second call and add to the affidavit before the motion to suppress starts. They could even add to the affidavit this issue during it, but it doesn't come up until the supplemental briefing. Is that right?
So, I don't think the issue is different. I don't think it's a different issue whether the warning needed to be in Spanish at all or accurate and complete. I think if we're all on the same page that Miranda was raised right at the beginning, which it was, that's almost the first thing they start discussing at the motion to suppress. It was no secret. So I don't think the Miranda gets a little more specific because it can address the trial testimony, but it doesn't add anything. Miranda was clearly at issue. And if there's any question...
Not because there was a suggestion that it was defective, that it was...
Our position has always been that there's, from then until now, that there was no competent testimony that the Miranda warning was given at all. That's
Which is completely different than defective. So it's not a game. It's not a game. Okay, the motion to suppress is about to start. The DA presumably has looked at the affidavit, figured out who he or she is going to call to testify. There's no suggestion that what was given was defective.
That part was ineffectiveness, and that's the ineffectiveness that I bought, that trial counsel didn't press on that. But what is, and that's why we need an evidentiary hearing on that particular issue. But what is preserved for direct review is the notion that there was no competent testimony that it was ever given at all. And
So let me ask you, in your motion for new trial, when you raised this, did you present any evidence as to what the Miranda warning was deficient in?
we don't know because as far as, we're concerned, there's no evidence.
Client didn't know what he was told.
My client's position is that he never got the Miranda warning. The Spanish-speaking officers, showed up and started asking him questions and talking to him. That's been his position from the beginning. There's no warning. And these officers, just to be clear, these officers that testified do not understand Spanish. So they cannot competently testify any different. They assume that some words were going back and forth in Spanish. It could have been Arabic, could have been French. Nobody knows. I take it that it's Spanish, but what was said is just not in the record. Mm-hmm. And so that would have to be established at an evidentiary hearing on the new trial motion. But I don't think this is much different than a case where we have two bicycle patrol officers that make an arrest, call the officer in the cruiser to come pick him up and say, Mirandize him on the way to the station and we're interviewing him there. Then at the motion to suppress, the only testimony we have is from the two bicycle officers. We don't have any competent evidence that the warning was given. And it's not hiding the ball. At the motion to suppress, it wasn't a game. Everybody knew it had to be in Spanish. The problem was the correct witness wasn't there. That's the real problem. Mm. And this isn't unfair to the Commonwealth. To read the police reports, which again are mentioned on transcript 1, page 1819, Noyes put it in his police report that he had to bring the Spanish-speaking officer over to give the warning because he couldn't do it himself. The prosecutor knew that this was an issue because her own witnesses brought it up. They introduced it into the
But when you combine that statement in the report, which is, I can't give the warnings in Spanish, so I called a Spanish-speaking officer to give the warnings, and then the Spanish-speaking officer shows up, your inference is you don't draw any inferences from that.
I don't think you can draw an inference under Article 12, which is the highest standard for fact finders, that just based on assumption, and that just to be clear,
Well, it's
that's
not
what
an assumption. He was brought there for this purpose, and that's what the police officers, and they testify at the motion to suppress hearing, right? We brought him there for that purpose, not to question him.
I agree, well, to question him as well, but I agree with you absolutely that that's the purpose that he was brought there for. But also, it's an inference, an assumption, whatever you want to call it, but it's not.
Well, he was, he was brought there to give the Miranda warnings, but that wasn't the only reason he was brought there, because the defendant could only speak Spanish. So they needed to have Officer Guillermo there in order to interrogate the defendant, so that he was there for more than just giving the Miranda warning. So at this point, we don't know if he just went right to interrogation, because there's no competent witness who can say what he said.
I agree with all of that, Justice Wendlandt, and that's my client's position. He tells me this Spanish-speaking officer showed up and he started asking me questions. I mean, that's, for all that we know, that is what happened. The testimony to the contrary is testimony by witnesses who just can't competently testify to that, because by their own admission, it's all uncomprehending. And that just is not admissible as evidence in the Commonwealth. I see that my time is up, so I can speak to the prejudice if you'd like, or else I can rest on my brief.
Let's do the second one.
Thank you very much.
Okay, Attorney Jansen.
Good morning, may it please the court, Catherine Jansen for the Commonwealth. I think the court kind of has addressed the main issue, which is whether or not this was properly raised under under Rule 13 to put the Commonwealth on notice about what the scope of the motion to suppress was. I think it's...
Well, counsel, let me, there's no chance you're going to go right into your argument with us today.
Figured.
But what was at issue that the defendant was looking to suppress? Weren't there admissions and inculpatory statements?
There were, and I think what
Specifically, what was he looking to suppress?
he was looking to suppress his statement that he was trying to hide the gun for his friend.
Okay. Now, if you begin there and now you start working backwards, so the only way the Commonwealth wins, and that gets to be used against the defendant, is if the Commonwealth demonstrates a knowing and intelligent waiver of his Miranda rights, right?
Correct, and
So if that's the case, even if it might be improperly styled by the defendant, ultimately, the Commonwealth knows ultimately what the defendant is looking to suppress. And the only way the Commonwealth can win and prevail on that motion is to show the adequacy of those warnings. So wouldn't you just by knowing what is looking to be suppressed, know that you've got to bring in Officer Guillermo? You have to bring him in.
I don't think that's necessarily true. I think...
How else would you show the adequacy of the warning?
I think you can show the adequate... Well, first I would point out that I don't think it's actually clear on this record. Everybody's assuming that the defendant doesn't understand English and the English warning that was given. There was evidence in the record, not only that he followed subtle English commands up until the point of arrest, which the motion to suppress judge found that he didn't speak English only once he was arrested, but also by the fact that the only testimony about whether or not the defendant spoke English or didn't speak, he said the officers basically, it was their perception that he didn't speak good English. I think we all know there are many people who are bilingual.
Yeah, but that ship sailed. He's raising the issue of the adequacy because he's trying to suppress his statement. So we're there. So if we're there, irrespective of what's in that affidavit, the burden the Commonwealth has to demonstrate.
Correct, and I think the Commonwealth can demonstrate that burden through the fact that English warnings were given that he necessarily understood, because just because he speaks Spanish doesn't mean he doesn't understand English as well. And there's evidence that he...
But there would have been no need to call the Spanish interpreter at that point, a Spanish-speaking officer.
I mean, I think I think it's in a...
So let me ask you a derivative of what Justice Georges is asking you. It's your burden beyond a reasonable doubt, right?
Correct.
If you got to this hearing and one of the police officer testified that warnings were given in Spanish and they were sufficient for Miranda, and there was an objection and it's sustained, don't you lose? Wouldn't that objection be properly sustained?
If Miranda was given in Spanish and the foundation of the officer's ability.
Yeah, if a non-Spanish speaker said, I was there, I saw Guillermo give him the warnings and they were proper, and there's an objection, that could be sustained, right?
It could be sustained, and the Commonwealth then would say, okay, we're on notice about the...
But the point being, as far as sandbagging, then you probably should have anticipated bring in the
Commonwealth-
the right witnesses.
I mean, this is.
It's
this-
a Miranda case, you have to bring the witness who gave Miranda.
I mean, I think this goes back to the purpose of Rule 13 and to put the Commonwealth on notice. It's not a heavy lift for the defendant who has the personal knowledge of the basis of the motion to suppress, that I don't speak English. And so that English-Spanish divide was never mentioned, to put the Commonwealth on notice and busy district courts.
Let me ask
I
you
mean,
an unfair question.
okay.
You have a district court, ADA calls you and says, we have a Miranda issue. Do you say, maybe call the witness who gave Miranda? Or you say, you better call the witness who gave Miranda?
Correct. I think you could call the witness who gave Miranda, but there was also evidence that English Miranda was given as well. And just because the judge found that Miranda was given in English and Spanish, and that valid waiver happened, that
But the judge didn't find. Did the judge find that he waived his rights in English? I didn't remember that.
Well, so the line is that the
says
defendant
the
was given
defendant-
Miranda in both English and Spanish, and then it goes on to state that the defendant was given in,
Oh, he says, I
in
find
his native
Miranda's wa- yeah,
language,
I find
and then I
Miranda
find a
waived.
valid waiver based on him speaking. But I don't think there's necessarily a finding in there that the defendant necessarily had to be.
Actually, I wrote it down. I find Miranda warnings conveyed to the defendant in his native language, and he made a voluntary waiver. So the judge actually did find it was in his native language.
He found it was in his native language, but he also found it was in English, and I don't necessarily think that holding goes as far, or excuse me, not that holding, but that finding goes as far as to say that a valid waiver could only happen after Spanish rights were
Counsel,
given.
can I ask you a question? How is it sandbagging when the defendant says, motion to suppress Miranda, for you to need to bring in the officer who gave the Miranda warning?
I think it's.
How is that sandbagging? Why isn't that just sheer logic?
Well, I think when you look at it, it's because this English-Spanish issue was not raised. I wouldn't say that everybody knew that the waiver only could happen after Spanish was given. I think
It turns out the officer on the scene understood that, right? Because the officer on the scene brought in Officer Guillermo.
they said there was no evidence after English Miranda was given whether or not that there was a failure to understand those English warnings. It was circumspect policing because the defendant didn't appear to speak English well. There was never anything that he didn't understand English. And in fact, Officer Noyes, I believe it's at transcript page 35, says he's speaking in English.
Unless there's a beyond a reasonable doubt inference that this defendant spoke English, then you lose?
I'm sorry, can you repeat that question? I wasn't.
You have to show that the defendant waived his Miranda rights beyond a reasonable doubt.
We do have to show that.
Okay, and so you're relying right now on this defendant's capacity to understand English.
I think that's part of it, but I also think under this court's holding in Perez, where there's testimony there from an English-speaking officer who didn't speak Spanish, that the defendant was given Miranda in Spanish, that was sufficient when the defendant didn't challenge
But there's
that
also,
officer's
in Perez,
ability.
they also have a written, he's reading from a card.
Correct.
right?
I would say, but I would know, and I know my brother makes much of the fact that there were other facts there, but there were 3 separate issues and 3 separate holdings in Perez that the defendant raised, and the court addressed each 3, and each one of those 3 issues would have been sufficient to show that Miranda was given adequately.
Can I ask a question? It's following up on Justices George and Wentland, because there's a lot else said. The incriminating statement is made in Spanish, right? So that presents a complication too, right? These guys have no idea. The 2 English-speaking officers, the statement about hiding the gun is given to Guillermo, right, in Spanish? So is that a problem? Is that a separate problem too, that we don't, without Guillermo, we don't know if any of this is said or done, is that?
I think that's a separate issue for trial about whether or not he said that.
Well, but the whole issue is the motion to suppress the statement. If we don't even, does that matter? I'm starting to wonder about Justice Wendland's question, which is, he's there for multiple reasons, and the whole context of this is a Spanish discussion, right? The whole thing is now about Spanish language. and these two guys don't speak Spanish, do it.
Well, I mean, only Officer Peter said he didn't speak Spanish. The other ones, there's no testimony or challenge or evidence about what their ability
No
is.
evidence in
Spoke
here.
Spanish, he wouldn't have called in Officer Guillermo.
I think it was,
Isn't that a fair inference?
I think it's a fair inference that he didn't speak Spanish, but I think there's a difference between potentially understanding Spanish, being fluent enough to give Miranda adequately and know what's being said or not said, and once they have Officer Guillermo there to.
Was not competent enough to understand legal Spanish, at least in his own estimation. Because he called, it's a fair inference because he called in Officer Guillermo, correct?
He did call in Officer Guillermo, and I think that's circumstance policing to.
In fact, he called Officer Guillermo in order to do the interrogation as well.
Well, Officer Noyes did speak to the defendant in English, so he spoke to the defendant in English, and the defendant responded in Spanish. There's no evidence that Officer Guillermo was translating the English questions to the defendant, which I think is important when we're talking about what the defendant understood and didn't understand.
With all these close calls, it falls back to who has the burden of proof and beyond a reasonable doubt, correct?
It does, Your Honor. And I think here, and I would cite again to this court's holding in Perez, where it wasn't challenged or raised at the motion to suppress below by either an affidavit or by the defense attorney
I get the distinction with sandbagging. So if the issue that's raised is I never got Miranda at all, then the Commonwealth says, well, we're going to put the witness on who saw them get Miranda.
Which
if
I-
the issue that's raised is the Miranda warnings in Spanish were deficient, then you have to call the Spanish.
Correct, and I think the fair inference about what the Commonwealth understood it to be was whether Miranda was given at all, and so they presented all evidence regarding Miranda, and they did a suspender and bootstraps approach to it by going very inclusive about what happened, and not just saying, yeah, he was Mirandized, by saying.
Counsel, let me go back to Attorney Spurlock's point, though. Assume for the sake of argument that we agree that all that was raised was, I didn't get it at all. But the only way for those statements to come in against the defendant is if the judge makes a finding beyond reasonable doubt that it was a knowing and intelligent waiver. Doesn't that implicitly, if not explicitly, also involve the adequacy of the warning?
I think it does.
So
but
if it does, don't you have to call Officer Guillermo? Even if we give you everything that we're talking about in Rule 13, that it says, I didn't get it at all. That you as the ADA get that, and you say, I got to do the math now. That the only way this comes in is to have some showing of the adequacy beyond a reasonable doubt. So I have to call Guillermo, even if it doesn't say anything more than, I didn't get it at all.
I think, well, maybe I would amend my statement. I go back to what I cite in Johnson, because in that case, that's an appeals court case, so it's persuasive. But in there, I guess the issue is whether Miranda was raised at all, not the adequacy of the warning. And so what was presented at trial or at the motion to suppress wasn't about the substance of the warning. So I guess my answer is we would just need to show that Miranda was given and that he waived Miranda after it was given.
How can you show Miranda was given if nobody speaks Spanish?
And I would just again point this court to Perez, where there's nothing in the record here to show that they don't have because it wasn't challenged by the defense attorney below, that the officers didn't understand that when they call an officer to a scene for the purpose of giving Spanish Miranda, they're watching him read from a card. It's the English card, but read from a card and give him the warnings in Spanish so they have the ability to recognize that. There's a difference between fluency and ability to recognize. And I think where it's not challenged below, like in Perez, that is adequate for the Commonwealth to meet its burden that Miranda was given and that a waiver was made.
Let me ask you about an English speaker. Suppose the issue is whether or not someone got Miranda at all, and the police officers testify. We gave Miranda rights, and I'm the trial judge going way back. We gave Miranda rights, and he waived them. Then you have to find you were given the specific Miranda rights beyond a reasonable doubt. I mean, just is a breezy, I gave them Miranda rights sufficient to satisfy the Commonwealth's burden, even with an English speaker?
I think if the issue is whether Miranda was given, and then yes, and then the defendant could challenge what was in the content of those
And
Miranda
that's-
warnings.
Right, and that satisfies your burden beyond a reasonable doubt?
I think so. I don't have a case directly on point that would say that.
Probably a reason there's no case.
Well, I
It would have to be this case if we do say that.
And doesn't Mubdi put the burden on you? Mubdi's like bare minimum, right? That the defendant has standing to challenge the constitutionality of the search and seizure. The affidavit must, under 13A2, must be sufficiently detailed to give fair notice to the prosecution of the particular search or seizure that the defendant is challenged, so the prosecution may determine which witnesses it should call.
I frankly think Mubdi should be walked back a little, and it's essentially obvious the purpose of Rule 13. The defendant can make this broad claim, and then it's up to the, Commonwealth to be clairvoyant, essentially, to say,
The guy who actually gave the warning?
I mean, there was another person who testified who gave the warning, but I don't think you can just say statements and then that's it. And it's not much to ask a defendant to narrow the issue, and it's clear the Commonwealth didn't understand that this was going to be the scope of the motion, because we would have brought in Officer Guillermo, because we did for trial. If Mubdi's going to require the Commonwealth to be essentially clairvoyant on these issues and go into like every single subsidiary issue that is encompassed
In the motion to suppress for the English portion of the Miranda questioning, did the Commonwealth go through and have the witness say, yes, I gave him Miranda warnings, this is what I said, this is what I always say?
No, Your Honor, it was just that I gave English Miranda warnings, and then the prosecutor asking them what happened, he goes, then I didn't know how well they spoke English, so I, stopped, and then I called the Spanish-speaking officer.
If that's the case, back to Justice Gaziano's point, if that's all the English-speaking officer said was the breezy, I gave it, and there isn't any competent testimony as to what Officer Guillermo said to the defendant, how is it the Commonwealth could sustain its burden? I mean, wouldn't that be a sea change in our law if we said that this was okay?
Well, I think the court has said that this is okay under Perez when it said this is, the officer gave these just the testimony, the officer gave Spanish Miranda warnings from a card. But I mean, I understand the court's point, and it's a difficult one, obviously, for the Commonwealth. The court has no further questions, I'd be happy to rest on my brief.
Thank you.